Ma'am, I want to say that I want to give notice to reserve all my rights and inform the court that I'm not here to testify or plead. I'm here to make a special appearance to challenge the jurisdiction only. I would like to see evidence of the affidavit of the people that I've hurt. This is a victimless crime if there's no one that I've hurt. Objection hearsay. Objection hearsay. I'm not a sovereign citizen.
All right, folks, buckle in, because we've got a wild one today. On the surface, this should have been the simplest case in the world. A speeding ticket. 92 in a 75. Open and shut, right? Wrong. Because instead of just owning, up, paying the fine, and moving on with his life, this guy decided to pull out the almighty sovereign citizen script. Like it's some kind of magic shield that makes laws vanish. And of course, he swears he's not a sovereign citizen.
Mr. Robinson, are you here?
I am here representing the name, ma'am.
All right, you need to start your video, please. And you are, is it Tremaine or Tremaine?
The name I'm representing is Tremaine.
Tremaine. And how do you pronounce your middle name?
J.
Tremaine J. Robinson.
On and for the record, ma'am, I want to say that I want to give notice to reserve all my rights and inform the court that I'm not here to testify or plead. I'm here to make a special appearance to challenge the jurisdiction only.
All right, anything else?
Yes, I would like to see evidence of a charging instrument.
Were you not given a copy of the ticket issued by Trooper Collins?
The charging instrument that I am referring to is a sworn affidavit of the client, of the person that I've hurt.
Now, this is a speeding ticket alleging that you did on March 27, 2023 at 8:48 a.m. operate a motor vehicle in Butler County, Kansas at the speed of 92 miles per hour when the posted maximum speed limit was 75 miles per hour. So this would have been out on the Kansas Turnpike, Highway I-35. Now, what else were you wanting to know, sir, as the allegations against you?
I would like to see evidence of the affidavit of the people that I've hurt. This is a victimless crime if there's no one that I've hurt.
Yeah, sure. Meanwhile, every single word out of his mouth sounds like it came straight from the Sovereign Citizen 101 handbook. First words, I reserve all my rights. I'm not here to testify or plead. I'm making a special appearance to challenge jurisdiction. Sound familiar? It should, because it's the same nonsense these guys throw around every single time. Then it gets better. He demands to see the affidavit of the people he's hurt. Because in his mind, speeding is a victimless crime. Folks, I couldn't make this up if I tried. He really believes you need a victim to get charged in traffic court. As if the law only applies when someone's sitting there in the witness chair, bleeding from your
Well, the victim would be the state of Kansas in that you violated the laws enacted to protect the people of the state of Kansas. But this is not the type of crime which would require or have individual names listed. So your next point, if any?
My next point is, as I said, ma'am, I'm not here to testify. I'm not here to plead. I would like to see the affidavit with 2 signatures for the person that I've hurt. If I didn't hurt anybody, there's no crime.
All right, well, I'm going to proceed. The subpoena was issued July 7, 2023 for Trooper Collins. Then on July 31st came a correspondence from the defendant as referred to by Mr. Regier herein. Looks like it's about 7 typed pages, and as counsel said, it's entitled Challenge for Jurisdiction and addressed to Butler County District Court Clerk, Butler County District Court Clerk, Office of the Attorney General Derek Schmidt. And it mentions subtitles, under the following case law, I request case 2023 TR 1193 be dismissed. Pretty much standard language that is used by folks who call themselves or are considered sovereign citizens. Quote, it is on this date, July 27, 2023, I, Tremaine J. Robinson, it's Tremaine-J, Robinson, in the county of the Seminole of the state of Florida and a zip code, a natural man, attorney in fact, as a living human being who's the beneficiary of Tremaine J. Robinson trademark. Swear that the information in my sworn statement is truthful to the best of my knowledge and understanding. I, Tremaine J. Robinson, beneficiary of Tremaine J. Robinson, revoke my signature on any and all pages of any and all tickets, summonses, contracts, and or agreements signed by the side of the road in the state of Kansas by Officer Collins K. And so here we are. Now, Mr. Robinson, normally I would be upset that you filed what appears to be in part a motion for discovery and you didn't get that. However, you did not address that document to anybody but Butler County District Court Clerk Traffic Court, Butler County District Court Traffic Court. You sent one to a P.O. box in Topeka, and then you sent a copy of it to the Attorney General. But you did not send it to the Butler County Attorney. Therefore, he did not know you were trying to get discovery.
Ma'am, I do have a tracking number that says it was delivered at the Butler attorney.
Okay, well, that's not on file. What you want to present that at this time?
Yes.
Reckless driving. Newsflash. Traffic laws exist to prevent harm, not to wait until after someone's already been plowed over. But of course, he doesn't see it that way. He thinks he's found the ultimate loophole. Meanwhile, the judge is sitting there politely listening, probably wondering how many of these sovereign geniuses she's going to have to deal with before lunch. And just when you think this guy can't dig himself a deeper hole, oh, he does. He claims he filed a 7-page legal masterpiece demanding the case be dismissed. He even mailed it out, supposedly. Only problem? He mailed it the day before the trial. That's right.
This document that I'm giving the benefit of, it's a multi-subject document, but this document filed by the defendant that I'm giving the benefit of, including what he offers as a motion for discovery, was not filed with the clerk until July 31st. So that was after the statutorily required 21 days. And then it was not filed upon the prosecutor who would have, or the witness who would have held any evidence, but rather again on Butler County Clerk in Topeka, Kansas, that to my knowledge doesn't exist, the Butler County Clerk in El Dorado, and Attorney General then Derek Schmidt in Topeka. And that's if it was served, if I take the defendant's benefit of the doubt, that it was saying it was served sometime yesterday before today's 1:30 trial, the court has to decide if that later time was reasonable. And I do not find that it was reasonably served on the county attorney. I am at this point going to say that any last minute motion for discovery is denied and we are prepared to go to trial. Now I've lost you, Mr. Robinson. Are you still somewhere available?
No.
What are you doing there with your computer?
Right now, I was looking for a document, but no, I am not available for trial.
His big strategy was last-minute discovery paperwork that never even reached the prosecutor. Folks, you don't have to be a lawyer to know that's not going to fly. So now the judge is staring him down, basically saying, nice try, but we're going to trial today. And at this point, you can already Feel the walls closing in on him. So the judge tells him, "We're moving forward. Put yourself on camera or you could be held in contempt." And what does our sovereign friend do? He literally says, "I'm not available for trial." Excuse me? Not available? Buddy, this isn't a dentist appointment you can...
Proceed with trial. So please put yourself back in front of the camera. Follow the court's order or you could be found in contempt. I don't want to do that. Thank you, sir.
Your Honor, in that particular case involved a sovereign citizen where the court noted in the memorandum opinion.
Objection, hearsay. Objection, hearsay.
Case law is not considered hearsay or...
I'm not a sovereign citizen.
All right, he's not a sovereign citizen. Go ahead, Mr. Regier.
Yes, Your Honor. In that case, the Kansas Court of Appeals noted, quote, the defendant thinks the law does not apply to him. He avows that he, unlike other citizens, is sovereign and immune from prosecution. The court went on to address the issue of venue, which the court noted that, quote, venue is generally proper in the county where the crime was committed. I will address that momentarily, as well as referring to KSA 22-2602. Additionally, and perhaps most relevant to this court, the defendant in that case, quote, complains that his objections to the trial court's jurisdiction to prosecute him arise from the claim that he is a sovereign citizen. This is not the first appellate court to deal with such a claim. Another panel of this court used analysis of federal case law to reject a similar claim. And then quoting from Seventh Circuit and Eighth Circuit cases, quote, an individual's belief that his status as a sovereign citizen puts him beyond the jurisdiction of the courts has no conceivable validity in American law. Regardless of an individual's claimed status of descent, be it as a sovereign citizen, a secured party creditor, or a flesh and blood human being, that person is not beyond the jurisdiction of the courts. These theories should be rejected summarily, however they are presented. And with that, I would respectfully call my first witness to the stand.
All right. I do find that this court has jurisdiction and venue to proceed, and the arguments made by the defendant in the 7-page document referred to previously are summarily dismissed.
Reschedule. You're in court. Right now. The judge is patient, but you can tell she's one step away from snapping. She orders him again, get on camera, stop playing games. And instead of cooperating, he keeps repeating his greatest hits. Objection, hearsay. I'm not a sovereign citizen. Objection, hearsay. Like a broken record. At this point, I half expect him to start shouting, "Uno reverse," and think the case disappears. Then the prosecutor jumps in, quoting case law, calmly explaining that sovereign citizen arguments have no value in American courts. Zero. Zilch. And this guy's sitting there acting like he's found the ultimate legal cheat code. He's not fooling anyone.
And did you ultimately write the defendant a citation for speeding?
Yes, I did.
Or an annual redirect? No further questions.
All right, Mr. Robinson, this is your opportunity to cross-examine the trooper. You can question him about his testimony. It's not quite time for you to give your own testimony, so these addresses to the trooper have to be in the form of question. You don't have to question him, but you can. Would you like to?
No.
All right. Mr. Regier, any further evidence?
None from the state, Your Honor.
Okay. The state rests then, Mr. Regier?
The state does so rest, Your Honor.
Mr. Robinson, the state rests. They have presented all the evidence they intend to. Would you like to present any evidence? Again, you don't have to. Your silence will not be used as a sign of guilt. But if you'd like the court to consider your position, I'd be happy to do so.
I don't understand.
Well, do you want to tell the court your version of what happened?
No.
All right. You don't wish to present any evidence then. Am I understanding you correctly?
The evidence that I tried to present, you won't give due process.
Okay, but But do you want to give any testimony about the events leading up to this ticket, March 27, 2023?
No.
All right. Well, I will find the defendant guilty of speeding 92 and a 75. The scheduled fine is $87. Court costs are $108. The total due will be $195. Sir, you do have the right to appeal this proceeding. You can appeal it to the Kansas Court of Appeals. You have up to 14 days to file that notice of appeal. Your appeal bond will be in cash, the same as what your court costs and fines are. That's $195. Can you have this paid, this fine and cost paid in 14 days, or do you need some time?
Especially not the judge. And here's where it all comes crashing down. The judge straight up dismisses his entire 7-page manifesto, just wipes it off the table. Boom. Gone. All of those natural man declarations, the weird signatures, the Florida zip codes, the whole thing. Worthless. You can see the look on his face. That sinking realization that his magic words don't work here. But does he fight back? Does he cross-examine the trooper who wrote the ticket? Nope. He just sits there in silence. This was his one shot to challenge the evidence, to at least try, and he folds. It's like watching a boxer refuse to throw a single punch. The state rests its case. The judge turns to him. Do you want to present any evidence? Tell your side of the story? And he flat out says no. Nothing. Not a word. The very same guy who spent weeks writing a mini novel about jurisdiction suddenly has nothing to say when it actually matters, and you already know where this is headed. And just like that, the hammer comes down. The judge finds him guilty. 92 and a 75. The fine, $87. Court costs, $108. Total damage, $195. That's it. After all that grandstanding, all the legal gibberish, all the I'm not here to plead, I'm here to challenge jurisdiction. He's on the hook for less than $200. The judge even gives him the option to appeal, but let's be real here. If his 7-page natural man manifesto didn't work, what chance does he think he has at the Court of Appeals? That's like bringing a squirt gun to a forest fire. And here's the best part. You can see it on his face. That look of shock, of disappointment. He really thought he was going to waltz in, throw out a few magic phrases, and watch the case evaporate. Instead, he walked out with nothing but a bill and a bruised ego. The truth is, this is the same ending for every sovereign citizen. They think they've found a secret hack to the system, but the law doesn't play games. You can shout objection, hearsay, until you're blue in the face, but it won't change the fact that speeding is speeding. So what do you think? Did this guy really believe his own nonsense, or was he just stalling for time, hoping the judge would get tired and give up? Personally, I think he genuinely thought he was the smartest man in the room. Spoiler, he wasn't. And that, my friends, is why these courtroom showdowns never get old. Watching reality crush fantasy in real time, it's priceless.